Hey, this is the last coffee house, so I just want to offer some thoughts on Brett Kavanaugh and his confirmation. I want to stay away from anything that has to do with platitudes, like paying lip service to categories of wrongs rather than genuinely expressing concerns about those areas, or simply regurgitating hedged language to offer something, worth the 2 cents into the sphere of discussion here. I'm greatly, and you might be able to hear in my tone, I'm very, very concerned with how this whole process went and how the discussion primarily, more than anything, how the discussion went and how people talked about it and what the propositions that they levied and the way that they supported those propositions and all that sort of stuff. That's what really, really bothers me about this situation. So number one, sorry, it sounds so dire, but it's a pretty serious situation. Number one, we can talk about a preliminary outline so we can kind of understand what is the context of this. The context of this is 2018. It's post-2016 elections. It's Trump derangement syndrome is certainly one aspect of the context that we have to be aware of when we're talking about the fitness of this particular person for the highest bench in the law in the country, in the third branch, and the validity of the claims that are levied. We have to consider that we're in this state right now. We're in Trump derangement syndrome country. So that's going to impact it. Not only that, but the fact that conservatives at this point, it's extremely important for them to force a conservative majority, having lost Anthony Kennedy, the one swing vote, pretty consistent swing vote on the court. So the conservatives, they really need to get a conservative justice in there and get him or her in there as soon as possible before the midterm elections, because that could have just torpedoed every ounce of planning that they had. By the same token, obviously, then somebody trying to avoid that would want to delay it as much as humanly possible by whatever means necessary. So not only that, but remember, there's one context that we could be talking about this, that we're literally just looking at, is this particular person fit to be a Supreme Court justice? What are the criteria? Here's the list of things that this person needs to have. So let's check those off as they have them, like they went to law school, check. Whatever the case might be, and you just go down, check them off. And okay, they're fit, leave it at that. But we're not in that kind of a discussion or that kind of a context. We're thinking about these lines of thinking all the way down the line where we arrive at externals that shouldn't have something to do with this particular analysis. And what I mean by this is people who down the line, whether they are liberal or conservative, who are thinking that there's a particular kind of case, like say Roe v. Wade or something like that, that down the line, this is my criteria for fitness. Are they going to judge one way or the other way on this particular case if it came before them, and that's my idea of what fitness is, period. So we have these externals that obviously could be influencing every ounce of decision that somebody could make on this basis. So with that context in mind, number one, I kind of tried to break this down. Remember, this is supposed to be about fitness of a person for the Supreme Court. That's what it's supposed to be about. That's all it's supposed to be about. So we can take it kind of down a line here, and I've got just some logical statements going down the line. So it could be, and some people, this is what it was, but it could be, okay, if allegations equal true, then Supreme Court fitness equals no. If the allegations are true, then fitness equals no. It's that simple, straightforward. There could be above this, there could be some other line, that allegations are true, but it still doesn't equal no for fitness, who knows. But we're just starting at this line, because this is as far as we got when it came to the actual hearings. And there's no time restraint. I mean, the only time restraint that there could possibly be is that it's 17 years old or older. Any of those things, if these allegations happen within that window, then they are disqualifying of a Supreme Court justice, period. We don't know 17 and below if he was 16, 15, 14, 13, and there are similar allegations, whether those would be similarly disqualifying. We don't know that. So moving on. Next, if allegations equal false, then Supreme Court justice fitness equals continue. You have to go down the line. So if the allegations are false, you move on to the next one. If the Supreme Court justice nominee has an unfit demeanor, if that equals true, then fitness equals no. That would be the next step. If unfit demeanor equals true, then fitness equals no. If unfit demeanor equals false, then fitness equals continues. Keep going down the line. And that's kind of how it was structured. If the allegations are falling, then you move on to demeanor. So demeanor is a problem, the way his demeanor was during the hearings. Okay, so this particular demeanor is unfit, that equals true. So then fitness is a no, you're not fit. And then, like I said, you go down the line. And then the other thing that came up would be like, if drinking lie equals true, if he lied about drinking, that equals true, then Supreme Court Justice fitness equals no. If drinking lie equals false, then Supreme Court Justice fitness equals continue. So you go down the line and try to find something else. So that's kind of the structure that fitness was being looked at under. That's what the analysis was looking like, is that it was this kind of binary. Now, like I said, they didn't get into anything about, okay, time restraints, or if these allegations are true, if these things actually did happen in the way that they were described, etc., then what is the impact on the fitness of a person being a Supreme Court justice? They didn't talk about that. We didn't get into that. It had nothing to do with that. The only talk was about, okay, fitness versus not fitness, based on a binary related to the allegations. Okay, so I just wanted to get that in there. So other criteria for being fit for a Supreme Court justice could be, and these are the ones that were floated out there throughout that I heard, some of which were kind of ridiculous. Number one, just to take it, this is kind of oblique to the discussion now, but impartiality is something that always comes up when they talk about Supreme Court justice. He can't be impartial. And it's hilarious to me because quite obviously, if you did just a basic statistical analysis of the decisions that came through, then none of the Supreme Court justices have been impartial when it comes to, they very often decide cases on ideological lines. It happens constantly. So impartiality, yes, I would love that. It would be wonderful. But to consider that a requirement of a Supreme Court justice, maybe they got onto the court and then you realize they're not impartial, but it's just one of those things. It's one of those lovely fictions that we like to dangle out there. Most of the Supreme Court justices, I know Roberts has voted otherwise on occasion, and I know the entire Supreme Court obviously has decided 8-1 or 8-0 or 9-0. They've decided altogether on some kinds of cases that might have had an ideological bent. But still, yes, there's partiality on the Supreme Court, and that's just something we got to deal with. Okay, but the other fitness question is, okay, how do the allegations work? Is it just, what's the level of evidence that's required? In a court of law, there's a certain level of evidence that's required for somebody to be convicted, for there to be consequences. It's not just, okay, well, we decide haphazardly that it's just fine. Yeah, we have all these levels, these thresholds that they have to meet to say that the evidence is sufficient to get a conviction to have these consequences. Here, the consequence is not getting the job. Obviously, it's not a criminal adjudication. I'm not saying it is, and I'll get to that more later. But right here, what we're talking about is, okay, so Supreme Court justice fitness equals not convicted of sexual assault. I think most people would be 100% fine on either side with that statement, that being a criteria for determining whether somebody's fit or not. So that's convicted of sexual assault. And there could be some kind of circumstances where somebody decries that and say, no, I mean, there are, if he was underage and it was expunged or sealed, he was juvenile. Of course, I say he because I'm sexist, but if it was something like that, then maybe they would still be eligible and it shouldn't be an issue. But convicted, I'm talking about, has gone through an entire criminal proceeding, and at the end of the trial, they were convicted and determined to have committed this act, whatever sexual assault is, under whatever statute we want to talk about that's sufficient to keep them off the bench. But okay, so most people would be perfectly fine with that. The next one would be Supreme Court justice fitness equals not accused of sexual assault with overwhelming evidence. So it'd be like they'd have to be accused of sexual assault, but there would also have to be overwhelming evidence. They weren't convicted, but there would be overwhelming evidence, whatever that threshold would be. We'd agree that that's overwhelming evidence of the sexual assault, therefore they're not fit. The next one would be beyond a reasonable doubt evidence. Then beyond that, clear and convincing evidence. And then more likely than not evidence. So all these tiers of evidentiary standards, and you could say that any one of those would be, okay, this is the threshold. If there's, because it's not a perfect world. We don't know 100% what happened. We didn't have cameras at the time. It's not Minority Report where we got the precogs who are telling us all these things happening and giving us video of it despite not having cameras there. So we'd have to figure out, okay, what's the threshold of evidence that makes it justifiable that we prevent somebody from being admitted to the bench. Now, the level that I heard from a lot of people on one particular side was simple accusations, was that accusations was sufficient to disqualify somebody. I know somebody specifically said that they were referencing another Supreme Court, it might have been Gorsuch, but they were referencing in another Supreme Court justice who made it through the confirmation, and they said that, yeah, he should have gotten through the confirmation because he wasn't accused of sexual assault. And it's just, okay, that would be the standard, is that any accusation, corroborated, verified, no evidentiary standard associated with that would be sufficient to prevent somebody from being a Supreme Court justice. We just need to be clear about what we're talking about here. If we're going to consistently use that standard, obviously, it could be anybody. I mean, anybody on the Senate Judiciary Committee could just say that, okay, I want to keep you off. I'm going to say that you sexually assaulted me, and that's an accusation, therefore you're off. You can't be on the bench, and they could just keep going back and forth on that. So we have to be very clear about what our standards are and how these are going to be applied in every possible iteration of this particular process. We still need Supreme Court justices. We still need to replace them when they're gone. Oh, and RGB is 85. I think I was just reading an article about her. She's 85 now. She's gonna try to wait out the Trump administration, and if he gets 4 more years, she's gonna have to wait even longer. She's gonna be 90 before she gets off the Supreme Court. She's been working hard for a long time, and she's gonna have to wait that out. Whatever the case, it's neither here nor there. So what I'm saying is there has to be some kind of a standard that we're applying here, and it has to be applied consistently. If we establish this now, it's a precedent that says that accusation, that's sufficient. That's enough. There doesn't have to be any evidentiary standard with it. And most people get that, but I wanted to break it down all the way down to every step of where we are in this process. Now, if it's beyond a reasonable doubt when it comes to criminal court, and in civil court, it's more likely than not. If we, said that the standard has to be clear and convincing evidence, if we ever get in this situation again, that it has to be clear and convincing evidence, then we need to stick to that standard. If it's one of those things where, not only that, but is it only this particular kind of crime or a different kind of crime too, or what? But if we want to pick a different standard, like say it's not a criminal case, so why not pick something lower? We're just trying to figure out if this person's fit, and if we have good reason to believe that it's the case, then we can shuttle them. Just clear and convincing evidence, or more likely than not. Clear and convincing is like 60% or 66% or something like that, but more likely than not, 51% likely we could say it is the standard. But still, I mean, all the way down to simple accusation, that's a problem, and that shouldn't be somebody's standard that they're advocating for determining. Now, there could be a whole bunch of people who are just saying that, no, we believe that it was clear and convincing evidence, and that's why we're on the side of it. At least they're using a standard. I don't think that's the case. I think there's all sorts of bias going in there if they want to say that that's the case. Anyway, we're going to get into it. So just moving on to the evidence, I wanted to lay that out very explicitly. So moving on to the evidence, Dr. Ford, her evidence is her testimony. And one of the big problems with trying to evaluate Ford or Kavanaugh is that most people, they want to say that just by instinct, they decided that one person or the other person is telling the truth or is lying. That is the most dangerous position that anybody can take when it comes to determining something this complex that you know so little about. It's just instinctively, I know, especially when it's completely politically driven and it's related entirely to all sorts of outcomes that would lead to virtually anybody trying to make this decision to be completely biased about who they're going to say is correct or not. So no, absolutely not. Throw it out the freaking window that I just instinctively know who's telling the truth or who's more credible when they're giving testimony or not. That's absolutely ridiculous. Not only that, but Ford and Kavanaugh had to testify in a context that is completely atypical to what 99.9% of the population observes on any regular basis. Ford and Kavanaugh have to testify in the context of Ford, she's in front of millions of people. I know I think it got up to like 87,000 people, whatever stream I was watching. 87,000 people watching this thing at one time, just on that stream. And there are a whole bunch of other streams, in addition to the people who were there and the people who would watch it later and all that sort of stuff. So just hundreds of thousands of people in different things watching at one time, and she has to talk about very personal things and is going to be completely scrutinized by everybody in the freaking world. And same thing goes for Kavanaugh. Everything that they say is going to be crazily scrutinized, and it's about things that they never talked about in public, that they never had an occasion to say anything about in any context when it came to a public forum like this. So this is completely atypical, and we're trying to instinctively instinctively understand this process and understand all the information that's coming out of both of them based on a completely atypical situation. So it's just, when it comes to your instincts about who's right, just, oh my gosh, just throw them out. It's something that could be peppered in as you're going through evidence and determining, okay, what's likely to be true under the circumstances. But my God, if you're using that as your basis, just shut up. Please shut up. So anyway, and I'm just going to do it like this. So the things I give her a lot of latitude on when it comes to the questions that were remaining were, number one, the length of time that she had. And latitude, I don't know why anybody wouldn't know this, but latitude means just like, and that's not like intellectual shaming or anything like that. But latitude is like giving somebody more space. It's just saying that, okay, benefit of the doubt, I'm going to give you more space on these things. Even though I have questions about them or they bother me, I'm giving you more space on them. So for Ford, I give her significant latitude when it comes to the length of time that she took to tell somebody. I think it makes perfect sense for somebody to be disinclined to talk about something like this, especially something that happened, near 40 years ago. In that context of that time, it would have been much less likely for somebody to bring it up, period, let alone bring it up, to their friends or call the police or whatever else. Especially the way that they're described, it's something that I can absolutely see somebody being unsure about whether this is illegal conduct, or this is something that you want to rile anybody, especially in a powerful sphere of society, whether you want to rile somebody up related to this. So I can completely understand that. It's the length of time alone, I think I can give a lot of latitude on and say that 36 years, yeah, it's a long time to not tell anybody. 30 years, until she told her therapist, mentioned it to her husband. I can't remember if she mentioned it to her husband around the same time for the first time, but whatever the case, 30 years, 36 years, I think she gets a lot of latitude in this area. Additionally, not expressing it to anyone at the time, the earliest being her therapist. I think to an extent, I give her a lot of latitude on that as well. The concerns I have with that is I wonder if she was in therapy previously, prior to this, if she was in therapy. Obviously, if she was and she had mentioned the incident and it had some information that exculpated Kavanaugh or something like that, then her therapist couldn't bring it up. It's completely protected. This is exactly the situation that rule is designed for, is that the therapist would not legally be able to bring up anything about it. But so I'd wonder if she brought it up to a therapist at some point when she's trying to deal with, because she's a scientist, she's a doctor, she understands these processes and how you have to deal with these. I'm sure she knows a lot about therapy in general and psychiatry, and et cetera, et cetera. So bringing up this kind of an attack, if it has this kind of an impact on her, she likely would have done she had a therapist historically. So that's the caveat that I add to that. But when it comes to not expressing it to friends or family, I think she gets a lot of latitude in that area as well. I think that makes sense. And there was one time, at a certain point, she was evading the question of whether other trauma contributed to her current symptoms related to PTSD and that sort of thing. And she was evading. Obviously, I can give her a lot of latitude on that because she doesn't want to, on a national forum, bring up other traumas that could be contributing. Even if there were other traumas that make up the lion's share of what led to her problems now, her psychological problems now, or just depression or whatever else. I completely understand, give her a lot of latitude when it comes to evading that question on describing other traumas in her life. Completely understand that. Okay, the things where I don't give her a lot of latitude, this is where I give her little latitude. Remember, these aren't 100% categorical here. This is saying that I give her a lot of space for one and just not very much space on these that I'm about to say. So the timing of them coming up, this really bothers me. And I think justifiably, objectively, it should bother just the analysis in general, is that she first mentioned it to her therapist that she was attacked by Kavanaugh, and these are what are apparently in the notes, when Mitt Romney was bringing up the fact that he thought that Kavanaugh would have been a good Supreme Court justice, or he was floating him as one of his primary choices for Supreme Court justice. And this is when she brings the attack up to her therapist. Like, that's very suspicious timing. Additionally, and then obviously the fact that she brought it up again right before his confirmation in the Supreme Court is again suspicious timing. You would wonder why, and so this chunk of it I give her latitude in that she didn't challenge him when he was becoming a Supreme or a federal court justice. You wonder why she wasn't concerned about him doing doing that at that time, or being a federal court justice. But I give her some latitude on that one, because you push it, if it was completely accurate, you push it back, you push it back, you push it back. And, this is the breaking point. This is the highest that he can possibly get. So I kind of see that, and I think she gets some latitude on that part of it. But anyway, so the timing that she only originally brought it up when Romney was floating him as a Supreme Court justice nominee, that concerned me for sure. And the fact that she submitted it anonymously at first just undercuts, and I kind of mean this in a weird way. It's like, I understand that she would want to do it anonymously just to get that information out there and not have to be involved with it. I get that. It's the fact that the need to get the information out there to make sure that he's not confirmed, because she genuinely believes that he shouldn't be eligible for it. Like, submitting it anonymously first is something that it doesn't seem right in that context. So not much latitude on that one. The failure of her and her attorneys to provide the therapist notes that are in question, just the ones that are in question, even if redacted all the way through, except for those particular notes, and the failure to provide the polygraph results. The polygraph test in general, there's a lot about that that's really weird. So the therapist notes, just a little bit of latitude on that one, because like I said, you can redact it. You can provide the notes that say, okay, this is where I said it, this is when I said it, and all that sort of stuff, without anything that has to do with any other aspect of her therapy sessions. But she didn't do that. And the polygraph results, she's a doctor. She's a professional in cognitive areas. She should be aware that most of the literature suggests that polygraphs are not reliable. I mean, I just watched, and she has to know this. There's no way she doesn't know this. I just watched, it was a video of a guy he says that he time traveled for the British government to the year 8900, and he saw half robot, half people who were immortal. And he passed a polygraph to that effect. He missed one question on the polygraph, and it didn't have to do with whether he had actually done the time traveling or talked to them. So anybody who has studied this to any degree knows that polygraphs are not reliable. That's why they're not eligible or admissible in federal court, is that they're not reliable. And yet she was kind of standing on it. And I was at work, I was in my office doing work at the time that I was watching these hearings, so I didn't see every little bit of it, but I watched the majority of it. But whatever the case, standing on those polygraphs or trying to use them as evidence without her at least couching it and saying that it's, just keep in mind that polygraphs, I took this polygraph and I passed it, but keep in mind that these things can be, they're not admissible in federal court, and the literature suggests that they're unreliable. So just take it with a grain of salt. If she had said that, then that's one thing. So just a little latitude on that. The fact that she wanted to use a polygraph, even though she had to know that those things are not reliable. So, and the fact that she never, and still isn't, even though the cat's out of the bag, she still isn't initiating an investigation with the Montgomery County Police Department. There's no reason to not do it now. The local police department, obviously, if when asked, they just said that it's beyond the statute of limitations, there's just no way to do it, then that's one thing. But I know I looked at the criminal code at some point. I was trying to figure out the statute of limitations on some crime, but it was some minor crime that has no statute of limitations anyway. So there might not be, or there might be. It depends on the jurisdiction. But I don't see any reason to not open an investigation now after everything's out of the bag. On her part, Maybe she doesn't want to have to answer any more questions. Maybe she just doesn't want to have anything to do with it now. She just thought she had to speak up. But, who knows? And then the fact that they were missing vital detail. I give her a little latitude for the missing vital details. The things like when she got there, to an even greater extent, how she got home, the location of the house, whose house it was, stuff about wearing the swimsuit and why she was in a swimsuit. I'm no professional. When it comes to these kinds of allegations, things that happened, and trauma and how you remember these. I know I just watched, it was some video where it was explicitly talking about, it was going through all the literature when it comes to trauma and memory. And it was fascinating. It was talking about how trauma actually, people think that when you experience trauma, it leads to better memories. Everything gets seared into your brain, but it actually overloads your ability to remember things. All the most current literature suggests that it actually overloads that ability to make accurate long-term memories when you experience trauma like that. But again, I'm not a professional. It's not my area, so I can't speak to that effectively. But when it comes to certain details, it's just like, those those details would have been extremely helpful in determining whether this was accurate or not, and they just happen to be the ones that are omitted. The things after get to the house, and you're just in the house, who knows what house or where, and all the things that happen there are many different scenarios that could link that particular event to a whole bunch of different things and people. So that's why that just bothers me, and I give her little latitude on that. Okay, so when it comes to Kavanaugh, again, instinct, no instinct about whether somebody's, you can use that when it comes to personal relationships and that kind of stuff. You can often be very accurate, especially somebody you know really well or whatever else. But when it comes to this kind of a scenario, you cannot rely on your instincts to determine whether somebody's truthful or not. So the things I give latitude on for Kavanaugh: beer. He said beer like 100 times. He says he drinks beer. And I give him significant latitude on that when it comes to connecting saying he drinks beer to being blackout drunk and sexually assaulting people. I think he gets a lot of latitude on there. His incensed demeanor when he was giving his initial statement, his opening statement, I think I give him a lot of latitude on that, because it would be understandable under the context of he's being accused of something like this at the last second. It would be understandable to be this angry and incensed. It would make sense. Of course, a lot of people would say that it's guilty conscience speaking, and who knows, it could be, but I think objectively it's more likely that somebody being falsely accused would have an incensed reaction like this, especially given the context of how the Senate Judiciary Committee had treated him prior to this, and then were treating him at the time, in calling him evil and that sort of thing. So I think that made sense, so I give him a lot of latitude on that one. And a lot of latitude in rejecting the other outlandish claims. Not every other claim, but the other outlandish claims. What's her name? Swetnick, and something on a boat, and some other things that he brought up that were alleged to have happened or included him, that he had just outright rejected. I give him a lot of latitude on that. I only give him a little latitude on his disrespectful tone with senators, whatever senator. There's the one, Booker, I think, that called him evil, and I can understand him being angry at those, but even the Democratic senators, I give him very little latitude on being openly disrespectful, especially as a nominee to the Supreme Court. I don't think he should have done that or been able to do that. I don't think it should have been in his vocabulary to be that disrespectful of that branch of the government. And I mean, not like challenging them. Challenging them is perfectly fine. It's when he would be all catty and ask them the question that they asked him and be like, "Oh, well, do you?" And he'd interrupt repeatedly. He interrupted Feinstein a bunch of times, and that bothered me. It's like, be respectful still. You're trying to protect your name. If you think that you're falsely accused and the evidence is on your side, then at least be respectful. You got to do your opening statement. You got to get all that anger out. Just be respectful. And when he was evasive about the FBI investigation, to some degree I can understand this. This is the little latitude that I give him, is that he might not wanted to have involved his family or his friends or friends who hadn't been involved yet in an ongoing investigation, and he might have been concerned about elongating the process until it got to, because who knows how long an FBI investigation takes. At that time I thought, what's going to take months to go through an investigation? I have no idea. So is that after the midterms that they're actually going to finish, and then it's not going to matter anyway because Democrats are going to get into, win a couple senatorial races, and then they won't be able to get him through anyway. But so those could have been some things that he was concerned about, but obviously he should have just said, the FBI investigated me 6 times. They can investigate me a 7th, 8th, 9th, and 10th time. I don't care. They can, no matter what they investigate or how often they do, they're not going to find anything. That would have been the response that I expected, and I didn't get that response. So that concerned me. So I give him a little latitude on that, just little. And he refuted certain allegations, but didn't speak on one particular allegation, from what I remember. And he could have, like I said, I watched the thing, but I was in and out because I had to do work. So one of the things it was the exposing himself at a party. That was the thing that he didn't explicitly, from what I remember, he didn't explicitly say, yes, that one, definitely not, that didn't happen. It was when he'd mention outlandish things, he'd go to the things that we didn't even know about as viewers. Something about a boat and some other stuff. And the one with Swetnick, calling those completely outlandish. But I don't remember him explicitly talking about the one exposing himself at a party thing. I don't remember that one specifically that he talked about. So I don't know if that actually happened happened or what. Anyway, so that's what I thought of his. Those are the ones I gave him just little latitude. So if I'm coming to a determination, like somebody, a liberal holds a gun to my head and says, you have to make a decision on which way do you go on this one. Preliminarily, prosecutor, obviously, she talked to both of them, and she wasn't a jerk to either one of them. She was still firm, and she followed trails that illustrated holes in testimony, and I appreciated that. I thought that she got to some very significant things, not just the obvious one about the being afraid of flying thing, but one of the big ones was whether she could hear the conversation between Kavanaugh and Judge, and at one point she said, yes, I heard them talking, and then she went back on that and said, well, I assumed that they were talking. That's very classic legal technique, getting somebody to say, yes, absolutely, that's the case, and then, well, I assumed that was the case. That's classic. And the prosecutor obviously pointed out that no witness that was named could corroborate, and no witness otherwise could corroborate the party even happening, let alone Kavanaugh being there. So those are the things to take away from the prosecutor. So yes, it is not a court of law. So it's not a legal standard thing that we're using. But courts are specifically designed to try to figure out what the truth is. That's why all those procedural and evidentiary rules and all that stuff, that's why it's there. It's to try to get to some kind of truth. It's not perfect by any stretch of the imagination, but it's a lot better than people just saying, oh, this is the truth. No, that's the truth. And let everything in no matter what. So, and it's very important. Like the reason people bring this thing up is because they want to talk about the presumption of innocence, and evidentiary standards. That's what they want to talk about. But the reality is, it's not just in a court of law that you have to have a presumption of innocence. It's philosophical bedrock that you have to have a presumption of innocence. It's philosophical bedrock that the burden is with the positive claim. If you were presumed guilty, then everyone would technically be guilty of everything, of all things at all times. That's how it would work philosophically. It has to be that everybody is in a null position, and that if there's a positive claim, then the positive claim has to come with evidence. And if the evidence is sufficient, then it supports the positive claim. That's how it has to be philosophically. Not just in a court of law, that's how it has to be philosophically. So if I had to take a position here, after looking at everything and analyzing everything, I would say that it's miles away from being enough evidence. There needed to be, if she had all of the details about it, how she got there, how she left, she knew everybody who was there, she didn't mix up anything about any of the details at the party or anything like that, but there were, she couldn't, say they couldn't get in touch of anybody who was allegedly at the party. If she had all those details, I'd still not think that it was sufficient to say, 51%. I don't think it would reach that threshold, even with all of those things. If she had one corroborating witness who was at the party and said, yes, I was there, then that would bump that above 51%. And you'd be looking at, are we getting it clear and convincing or beyond a reasonable doubt? And then you'd have to wonder about, okay, when they're dueling over what actually happened in there or whatever else. But I think it's just miles from being enough evidence to say that this happened in any context related to trying to determine fitness or legal liability. So that's where I would stand if I had to pick one of those things. And obviously, again, I don't want to traffic in platitudes where I have to say that obviously it could have happened and we just don't have the evidence to support it. I don't want to have to go into that. Obviously, it's the case that if there were more evidence, then it would support it and we'd have it, and fine, we'd be able to show that yes, it happened, and we could say whether it disqualifies somebody from the Supreme Court or not. Now, I think the only concern that I would have is the time, is the minor versus 36 years and then getting here. That would be the only thing that I would be concerned about. Like if a nominee for Supreme Court justice did this as an adult, not even the time in between, but just as an adult, because I'm concerned about juveniles. We say that they're not able to make competent decisions in a million different ways, but we also say that we have to hold them to the standard that's going to travel with them for the rest of their lives. I do a lot of expungements for people, and I don't want them, they shouldn't suffer for bad decisions that they made really early in their life for the rest of their life. It shouldn't prevent them from getting any job anywhere, so they have to be on the streets and begging and all that stuff for their entire lives. So I'll get to biases, but that's one bias I didn't write down that I could have related to this. Okay, let's lab it. Let's get into my limitations. I'm not a criminal prosecutor, so I don't have necessarily those particular skills or abilities to be able to go through all of that to determine who's correct and who's not. I'm not a psychologist or therapist or psychiatrist or cognitive scientist, so my interpretation of the literature or ideas related to those categories, or who's telling the truth, how long it would take for trauma to, what somebody would do in the face of trauma or whatever else, you have to take all that with a grain of salt and take it with the anchor. So we're talking about really complex issues here. We're talking about Supreme Court justice standards, underdeveloped evidence that's from 30 years ago, from multiple allegations dealing with multiple people. It's a complex web of 36-year-old facts. I wasn't alive at the time. I don't even know what it was like at the time, so it's very difficult to kind of understand the context of it. And we're in the most politically biased time in memory. I mean, this is worse than the Bush years. This is insane. So I think it's pretty heavy. All those things complicate it so much that I have to be very concerned about whatever propositions that I'm going to stand on. That these are my opinions related to this. So I'm saying 1,500 pounds, like I said, it's out of a ton, so 1,500 pounds. Very heavy. That's what's weighing down my confidence in the propositions that I'm levying, that I'm setting forth. My bias, I don't like PC culture. I think it's excessive and ridiculous, and it's really attacking free speech generally, which is really a problem. It's the biggest problem to me. Free speech is the number one most important thing that we must have. If we don't have that, then it's a real problem. So with PC culture, I probably have a pretty significant bias against anything that has to do with that. So that's a bias that could be animating my decisions in this. I'm also a man, so I could be concerned about my displacement of men in power or something like that. So that could be animating my interests. I generally have a deferential posture towards judges, so that could be affecting my interest, but I have a deferential posture towards doctors as well, so, but I think more so towards judges because I have to. So it's possible that could be a source of bias. And on one side, it's so much emotion, my emotions. On the other side, it's where's the evidence. So, and the emotion side could be correct. It very well could be correct. I have a huge bias against emotional reasoning in general, so anybody who's trying to use emotional reasoning to come to some kind of a conclusion, especially when it's up against evidence, that's a freaking problem. So that could be a very source of bias. But anyway, that's the last coffee house. It's pretty lengthy, and I appreciate anybody who listened to it. Let me know what you think about it if you think I'm wrong. Obviously, I don't want to be wrong for a second more than I have to be, so anybody correct me on anything. I'm happy to hear it. But whatever the case, I hope all is well. And I hope this country can do something. I used to love this country, and every time I read the news now, and it's getting worse and worse. And I think I'm going to do some kind of a podcast on this, but I really think it has a lot to do with Twitter and on one hand, and news outlets having to survive in a new kind of economy. I think these two things together are just eviscerating the foundation of the Fourth Estate, and people in general are just, it's like widespread. It's like that movie Contagion, but it's a Dunning-Kruger effect. It's just everybody's catching it over Twitter, and it's so bad. But anyway, that's where I'm at. And this is the last coffee house. I'd appreciate subscribe or send me an email or whatever else. I'd really appreciate it. I hope all is well. Bye.